Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspectives of educational administrators and policymakers. This is episode 49. In this episode, I'll introduce a case about transgender athletes in school sports. West Virginia v. B.P.J. decided today, June 30, 2026, by the United States Supreme Court. This case decides whether public schools and state athletic associations can maintain female sports categories limited to students who are biologically female, and whether doing so violates federal law and the Constitution. Here is the background of the case. In the summer of 2021, a middle school principal in Bridgeport, West Virginia, received a parent's call, and the conversation that follows will eventually reach the steps of the United States Supreme Court. The student at the center of this case is B.P.J. We use initials because she was a minor. B.P.J. was assigned male at birth, but from early childhood, she identified as a girl. Her family describes her as consistently and persistently identifying as a female since she was very young. In the third grade, she socially transitioned. She began living as a girl at school using a female name and wearing girls' clothing. Before she ever went through male puberty, she started puberty blocking medication. When she entered sixth grade, she also began hormone therapy to undergo a female puberty. By every social marker at her school, she was understood and accepted by classmates and teachers as a girl. B.P.J. wanted to do what many sixth graders want to do, join the cross-country running team and the track team. Both were girls' teams at her school. When she tried to participate, her school's principal told her she could not. The reason was that a West Virginia state law passed in 2021 called the Save Women's Sports Act, which prohibited students assigned male at birth from participating on female athletic teams. The law said if you were born male, you play on male teams. The principal applied the law as written. B.P.J.'s family sued. They argued that the law violated Title IX of the Education Amendments of 1972, which was the federal law that prohibits sex discrimination in schools receiving federal funds, and that it also violated the Equal Protection Clause of the 14th Amendment to the United States Constitution. While this case was working its way through the courts, a federal district court issued a preliminary injunction allowing B.P.J. to participate in girls' sports while the litigation continued. During that time, B.P.J. competed on girls' cross-country and track teams. She won the West Virginia Class AAA state championship in girls' shot put. This case consolidated with a related Idaho case, Little v. Hecox, involving a similar law and a similarly situated transgender athlete named Lindsay Hecox, who also challenged Idaho's Fairness in Women's Sports Act. Both cases asked the same fundamental questions. Both came before the Supreme Court together. There were two legal questions that the Supreme Court agreed to answer. First, does Title IX require schools to allow transgender girls to participate on girls' athletic teams? Second, does the Equal Protection Clause of the 14th Amendment prohibit states from maintaining girls' athletic teams that are limited to students who are biologically female? Those are the two legal questions, and today the Supreme Court answered both of them in a 6-3 decision. Let me walk you through how the court analyzed each question because the reasoning matters as much as the result. Title IX says that no person shall be excluded from participation in any education program or activity receiving federal financial assistance on the basis of sex. That language sounded like it might prohibit everything we just described. But the court said, look more carefully. Justice Kavanaugh wrote the majority opinion joined by Chief Justice Roberts, Justices Alito, Thomas, Gorsuch, and Barrett. The majority began by asking, what does sex mean in Title IX? The answer is that in the context of athletic participation under Title IX, sex refers to biological sex, male or female, based on reproductive biology and genetics. The court looked at how the term was used in 1972 when Congress enacted Title IX and concluded that the ordinary meaning of the term sex at the time of enactment in the early 70s was biological sex and not gender identity, particularly in the sports context. And the majority opinion emphasized the term cannot plausibly be interpreted to refer to anything other than biological sex. The court pointed to two specific provisions of Title IX that it said explicitly permit sex-separated athletic teams. The first is what the court called the Javits Amendment. The Javits Amendment passed just 2 years after Title IX in 1974. Named after Senator Jacob Javits of New York, the amendment directed federal officials to develop regulations implementing Title IX in athletics to recognize that athletic competition often requires different rules than other educational programs. Congress directed the Department of Health, Education, and Welfare to promulgate regulations that shall include respect to intercollegiate athletic activities, reasonable provisions considering the nature of a particular sports. The court read this as congressional awareness that male and female sports would be organized separately. The second provision is in a regulation promulgated in 1975, which states that schools may maintain separate teams for members of each sex, where selection for such a team is based upon competitive skill or the contact nature of the sport. The court noted this regulation has been in place for over 50 years, was enacted pursuant to a congressional mandate, which was the Javits Amendment. The court's conclusion on Title IX is Title IX permits schools to separate athletic teams on the basis of biological sex, and nothing in Title IX requires schools to allow transgender girls to participate on female teams. Schools are not violating Title IX when they limit female athletic teams to biological females. The second question was constitutional. Even if Title IX permits sex-based teams, does the Equal Protection Clause of the 14th Amendment prohibit states from classifying athletes by biological sex when that excludes transgender girls? The Equal Protection Clause of the 14th Amendment provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. When a law classifies people based on a characteristic, courts apply a level of scrutiny to determine whether the classification is constitutional. For sex-based classifications, courts apply what is called intermediate scrutiny. We talk about 3 levels of scrutiny in our class. Under intermediate scrutiny, the government must show that the law is substantially related to an important government interest. This is a meaningful but not insurmountable standard. It's less demanding than the strict scrutiny applied to race classifications, but more demanding than a simple "is there a rational reason" test. The majority held that West Virginia's Safe Women's Sports Act satisfies intermediate scrutiny. The government interests the majority identified were 2: competitive fairness and physical safety. The court agreed that they are important interests, and the court said classifying athletes by biological sex is substantially related to both of the interests. Why? The majority relied on the undisputed proposition that biological males generally possess inherent physical advantages in sports. Specifically, the court detailed physiological characteristics that produce those performance advantages, noting that males have inherent advantages in height, weight, muscle mass, heart capacity, lung capacity, strength, speed, endurance, jumping ability, and so on. Quoting past precedent, the majority emphasized that these physical differences between men and women are enduring. To further illustrate this biological reality, the court cited findings from the International Olympic Committee that biological males have a performance advantage in all sports and events that rely on strength, power, and/or endurance, and noted that current evidence does not show that puberty blockers or hormone therapy eliminates this advantage. Because of those inherent physical differences, the court concluded that excluding biological males from female competition is substantially related to the important government interest of ensuring safety and competitive fairness. On the issue of safety, the majority warned that allowing biological males to play on women's and girls' sports teams can put women and girls at a significant risk of injuries. The court noted that those safety risks are at their apex in contact sports like soccer and basketball, but also exist in ostensibly non-contact sports like volleyball or softball. Regarding competitive fairness, the court stressed that sports are generally zero-sum. Allowing a biological male athlete to compete on a girls' team necessarily displaces and disadvantages a female athlete by taking away roster sports, playing time, starting position, or championship medals. Ultimately, the court ruled that drawing a biological line is a reasonable and constitutionally permissible way to reduce the risk of physical injury and ensure fair competition. Here is where the dissent pushed back. Justice Jackson, joined by Justices Sotomayor and Kagan, wrote separately in dissent. Justice Jackson made an argument. B.P.J. never experienced male puberty. She began puberty blockers before any male puberty occurred, and then underwent a female puberty through hormone therapy. The athletic advantages of male puberty cannot be the justification for excluding someone who never had male puberty. Justice Jackson argued the case should have been sent back to lower courts for factual findings about whether students like B.P.J. who transitioned before male puberty actually have the physiological characteristics the law assumes. The majority's response was this: the Constitution does not require schools or states to conduct individual physiological assessment of every athlete. Schools can use biological sex as the classification line because it's a workable, administrable rule that is substantially related to the identified interests. A rule that required case-by-case physiological assessment of every transgender athlete would be nearly impossible to administer and would itself raise serious privacy concerns. So the Supreme Court held, first, Title IX does not require schools to allow transgender girls to participate on female athletic teams. Second, state laws limiting female athletic teams to biological females does not violate the Equal Protection Clause of the 14th Amendment, because biological sex is substantially related to the important interests of competitive fairness and safety. Schools with such laws in place are on constitutional ground. Schools without such laws are left with an open question, which I'll address directly in a moment. Now, let's talk about what this means for you as educational administrators. I'm going to walk through this very carefully because there are things this ruling does decide and the things it explicitly does not decide, and confusing them could create real problems for your organization. If your school is in a state that has enacted a law limiting female athletic teams to biological females, laws like West Virginia's Save Women's Sports Act or Idaho's Fairness in Women's Sports Act, today's Supreme Court ruling gives you the clearest constitutional validation. In state of Georgia, we have a law that is functionally similar to West Virginia's Safe Women's Sports Act and Idaho's Fairness in Women's Sports Act, although the Georgia law has a different name. Georgia's law is called Senate Bill 1, 2025, officially called the Riley-Gaines Act of 2025. It was signed by Governor Brian Kemp on April 28, 2025, and became effective on July 1st, 2025, almost a year ago. With this Supreme Court decision, those state laws stand. Apply those laws does not violate Title IX, and it does not violate the Equal Protection Clause. You may think, doesn't Title IX prohibit discrimination based on sex? Aren't we discriminating against transgender girls? And the court is telling us, under the specific framework Congress established for athletic programs with the Jabez Amendment and the 1975 regulations, maintaining sex-separated teams, based on biological sex is not the kind of discrimination Title IX prohibits. Title IX itself anticipated sex-separated athletics. The 1975 regulation permitting sex-separated teams has survived multiple administrations and has never been repealed by Congress. The legal foundation here has been part of the fabric of Title IX athletics since the beginning. Here is the part that will require your careful attention and where many news headlines may get it wrong. The Supreme Court today did not decide whether the school that voluntarily allows transgender girls on female teams is violating Title IX or the Constitution. That question is open. You may be thinking, that can't be right. The court said biological sex classification are constitutional. Doesn't that mean letting transgender girls play is illegal? No. And this is a subtle but important point. The equal protection ruling means the Constitution permits but does not require sex-separated teams based on biological sex. States and schools that choose differently have not been told by this court that they are acting unconstitutionally. States may still have their own anti-discrimination protections that bear on this question. If you are drafting or revisiting athletic eligibility policies right now, you need to know exactly what legal framework governs your jurisdiction. State laws, state constitutional provisions, civil rights statutes, your state athletic association's rules, and then Title IX and the federal constitution. This ruling settles the federal constitutional floor. It does not settle everything above that floor. Now, another powerful teaching moment in this case is that even when the law is clear and after today's ruling in states with these laws, it is clearer. Your process matters. When you are applying a policy that restricts a student's participation in an educational activity, ask yourself 4 questions before you act. First, what is the specific legal authority for this decision? The statute, the regulation, or policy? And can I cite it precisely in my writing? Second, have I communicated the decision and its basis to the student and the family in a clear, respectful, and written form? Third, does my institution, my school district, my college, my university have a process by which a student or family can seek review, reconsideration, or accommodation? And have I told them about it? And fourth, have I documented everything, the decision, the authority, the communication, and any response from the family? The process applies here, but it applies far beyond athletic eligibility. Think about it the next time you are suspending a student, denying a course waiver, removing a student from a program, or implementing any policy that restricts a student's access to an educational opportunity. The same 4 questions protect you legally and, more importantly, treat students with the dignity they deserve, even when the answer is no.